So please, Professor Mendez.
Thank you very much. First, thank you very much to the organizers for giving me the honor of participating in this event, particularly the privilege of sharing the panel with Helen and with Lee. I especially want to thank Barb and Paula for thinking of me for this event and congratulate you on this brilliant idea. I am less sure that I should be grateful for putting me up after the panels of this morning, because those are difficult acts to follow. But nevertheless, I want to stress that the morning has shown us that all conflicts, including conflicts in neighboring countries, are different. They are significant in their own right, in their own context. Not only all conflicts are unique, but all transitions are unique as well, and all forms of conflict resolution are unique. And nevertheless, all of them, and especially these two, yield very significant lessons that can be learned and can be applied, mutatis mutandi, of course, in different contexts and different conflicts as well. One important lesson that El Salvador and Guatemala present is that it is possible for the international community to cooperate in the search for peace and in the search for justice, and that one does not have to yield to the other. In fact, of the international community's interventions in conflicts, these are the early ones in which this idea that the whole country has a legitimate expectation for peace, but the victims also have a very legitimate expectation and right to see justice done, has become a model that unfortunately not always has been followed in more recent conflicts. I think the Guatemalan peace accords benefited from the experience of El Salvador that had happened only a few years earlier, but also of trends in Latin America, and particularly beginning in the Southern Cone, about what states owe to the victims of very serious human rights violations, what societies owe to themselves when confronted with legacies of very serious human rights violations. So in the case of Guatemala, the UN played an important mediating and facilitating role, perhaps not only by brokering a peace agreement under these principles that I mentioned a minute ago, but also for deploying and engaging a civilian presence to make peace possible first, and then to guarantee as much as possible that the post-conflict situation would respect those agreements. In that context, it generated a UN doctrine about peace and justice that was reflected, for example, in the 1999 guidelines for mediators that the UN adopted. Unfortunately, a document that, although has been ratified a couple of times in 2005 and later under Ban Ki-moon as well, it has never been published. Nevertheless, it is a document that says that the UN mediators cannot accept transactions in the pursuit of peace that can sacrifice some important principles of international law. And even more important, and this is a published document, the doctrine is reflected in the 2004 report of the Secretary General called Rule of Law and Transitional Justice in Conflict and Post-Conflict Situations, that elaborates on all of these principles that we now call transitional justice, but also establishes that the United Nations will help societies that want in good faith to abide by these principles and participate in them. We know that the so-called Historical Clarification Commission whatever euphemism was used, did act as a veritable truth commission in the best sense of the word, in the sense that it produced much more truth about what had really happened than what we knew before its installation, but also that it created a process that has been repeated elsewhere, by which the most important thing is to hear the victims, to let them tell the story, and for the report to reflect. I think what distinguished the Truth Commission in Guatemala was some of the methodological aspects that were discussed by Professor Tom Mushat and Mrs. Coti earlier today. By this I mean that the process itself benefited from a really strong deployment of investigators and interviewers throughout the country and even in the most remote areas of Guatemala, instead of just opening an office and letting people come up if they want to tell their stories. Again, this is one of those hallmarks of what we now consider the best practices about truth commissions. And the other important characteristic of the Truth Commission, this is of the report, is that it dared to call genocidal acts by their name. We already heard how complicated that was and how fraught with political pressure that is. But the most important thing is not only that the commissioners decided to use the proper name for what had really happened, but two things. One, they did it on the basis of very, very serious and good evidence gathered extensively throughout the countryside. And second, they did so with a very rigorous legal analysis of what constitutes genocide under international law and how the fact patterns in Guatemala clearly fitted that definition. I would also like to mention that the process itself of the Guatemalan Truth Commission benefited from an extraordinary civil society effort that was also mentioned today, the REMI project, the Recuperation of Historical Memory project, that was directed by the Catholic Church, that also meant gathering archives from very remote parishes where people had told their stories, and for years these stories had remained in files that very few people read, but that anybody who wanted to walk in and ask a priest whether they had some stories about it could learn. The fact that this effort cost the life of Monsignor Gerardi is also something that we should bear in mind today as we try to get lessons learned from the Guatemalan process. And a very significant aspect of the Guatemalan peace process was that the amnesty law that was agreed upon in the peace process and as enacted immediately at the end of 1996 is the first amnesty law in Latin America that complies with international law because it excludes certain crimes from the benefits of amnesty. We knew then, and we unfortunately, the events have confirmed, that that's not enough to have justice, but it is the removal of an obstacle that, at least in Latin America and certainly in Guatemala, because there had been amnesties at every a couple of amnesties each year, even during so-called democratic governments, every time that there was a revelation of an event, there was almost an immediate blanket amnesty. And in this process, Guatemala shows the trend towards the rest of the world that some crimes are just so egregious that they cannot go unpunished. And the law has to reflect that. And it did. Obviously, the process has had and still has limitations. I don't have to tell you that there is a justice deficit in Guatemala. That almost sounds like a euphemism. But there are efforts, and they were highlighted today. The fact that there was a trial and a conviction of General Rios Mon for genocide is a significant achievement, even if it all came to naught by some far-fetched formalistic legal interpretation. The word technicality doesn't even begin to tell the story about it. But the case is not closed. The case has been reopened. And as we heard also this morning, there are several other cases like that where very brave fiscalas, as you call them, and judges are leading the charge and opening the doors of courthouses to see justice done for the victims. In the truth-seeking and truth-telling area, which is really the subject of today, I think we need to remember that this obligation of the state to tell the truth is not satisfied only with a truth report. It is an ongoing responsibility of the state to keep digging and keep finding the evidence of what happened. Like our friend Jose Salaquet has said, it's important to give each family an individualized truth. It's also important to give a social truth to the nation. But it's very important to consider this a right to the truth by the families. And in that sense, there's lots to be done. There's lots of fate and whereabouts of the disappeared still to be established, and particularly a lot to determine about who gave the orders, who complied with them, who used the power of their offices to shield accomplices from investigations, etc. Until all of that is established, the obligation in Guatemala will still be there, and it will be up to the civilian society to continue pressing for it. There's also the need to follow up on recommendations of the Committee of Historical Clarifications. I don't know if an effort has been made, but whenever there's a Truth Commission reports, there are numbers of recommendations, and it's important to go back to each one of them and determine what's the status of implementation of those recommendations. And in the area of disappearances, I already mentioned the encouraging developments that we have, but they're only encouraging. They're not fruitful yet, and it's important for all of us in the international community, and especially for Guatemalan civil society, to give the political and moral support that these efforts deserve if they are going to succeed. I draw some encouragement from the fact that despite the attempt of President Morales, CICIG is still there. CICIG is there, and it's creating some kind of bulwark, at least, against the efforts at impunity, impunity for past crimes, but also impunity for corruption now, impunity for current crimes, I would say as well. Yes, thank you. I just want to finish by drawing a couple of conclusions, drawing us back to what we call transitional justice, that is both a societal effort and practices that are shared among nations, but also a set of obligations by the state, a normative framework now clearly established as part of international human rights law that demands from the state certain behaviors. So first, those behaviors have to do, as we know, with truth, with justice, with reparations, and with measures of non-repetition, or what we sometimes call institutional reform. In all of those areas, there's a lot for Guatemala to still do. It's important that the four obligations have to be articulated, that there should be cooperation between each of them, that the Truth Commission report should be followed up, for example, with reparations, but also with prosecutions, and that the measures of non-repetition should draw the measures should be drawn from the lessons learned in the process of truth seeking and truth telling. The worth or the assessment of the relative success or failure of a Truth Commission has to be first the process, and in this case the Truth Commission of Guatemala is a stellar success, and do we know more at the end of the process than we did before? And again here, this truth report passes that test with flying colors. I would also mention that reconciliation has to be understood as transformation. I think this morning, I think Doug Castle said that it's not enough just to go back to the way things were before the conflict. We need to transform the society. And in that sense, we cannot just consider a society reconciled unless we make an effort to transform it in the sense of providing for more inclusion, less difference in treatment, and particularly much less discrimination of all sorts. And my final point is that all of this requires understanding of the measures of non-repetition as being centered around memory. It is memory that will allow us to transform. It is memory that will make us know what to do with the product of a Truth Commission, of prosecutions, etc. And I think Guatemala is another example, and not the least one, where the desires for justice live on no matter what the obstacles that are presented on its way. And in that sense, it is memory of what happened in Guatemala that will be the best way to move forward in the transformation of the society on the basis of what we've learned about this conflict and its tragic consequences. Thank you very much. I'm sorry.